Before we begin, it is critical to understand that the information in this presentation is for educational and informational purposes only and does not, under any circumstances, constitute legal advice. I am not your attorney, and viewing this video does not create an attorney-client relationship. The divorce process is incredibly complex and highly specific to the laws of your state and your unique personal circumstances. It is essential that you consult with a qualified legal professional in your jurisdiction for advice tailored to your specific situation. They thought it would be simple. Let's call them Mark and Jennifer. After 12 years of marriage, they sat at their kitchen table, a place that had hosted countless family dinners and homework sessions, and made the hardest decision of their lives. They agreed the marriage was over. It was sad, but it wasn't a war. They agreed on how to split the bank account. They agreed on who would get the house. They even sketched out a co-parenting plan for their 2 young kids on the back of a napkin. They promised each other they would do this the right way, the conscious uncoupling way, for the sake of the children. They were going to be the exception. So they each did what you're supposed to do. They hired lawyers. And that's when their simple, amicable agreement turned into a 14-month, $70,000 nightmare. Suddenly, the house they'd agreed on became a contested marital asset. The parenting plan napkin was replaced by dueling custody evaluations. Their lawyers, trained to fight and win, started digging. Text messages were taken out of context. Old arguments were weaponized in sworn declarations. Mark and Jennifer, who had started as 2 sad people trying to do the right thing, were transformed into opposing parties in a lawsuit. Their lawyers called it zealous advocacy. They called it hell. By the time a judge banged a gavel, they weren't just divorced. They were financially broken and emotionally destroyed, barely able to look at each other at their kids' school events without feeling a fresh wave of bitterness and regret. This story isn't just true. It's terrifyingly common. It happens every single day in every city across America. And the most tragic part? It was almost entirely avoidable. Mark and Jennifer made a single fundamental mistake right at the beginning. A mistake born from a complete misunderstanding of their options. They chose the wrong tool for the job. They assumed their only path was through 2 opposing lawyers, battling it out in an adversarial system designed for conflict. They didn't know there was another way, a fundamentally different approach that could have preserved their money, their dignity, and their co-parenting relationship. That's why you are here. In this video, we are going to pull back the curtain on the 2 primary paths you can take through a divorce in the United States. The path of the lawyer and the path of the mediator. These are not the same thing. In fact, they are polar opposites in their approach, their goals, and their outcomes. Understanding the 5 key differences between them is not just academic. It is the single most important piece of knowledge you can have at the start of this journey. This knowledge will empower you to make a conscious, informed choice. A choice that could be the difference between a $70,000 war and a $7,000 solution. It's the difference between ending your marriage and destroying your family. So let's get into it. The first, and arguably the most important, difference between a divorce lawyer and a mediator comes down to one simple concept: role and allegiance. Who do they work for and what is their primary job? Let's start with the lawyer. When you hire a divorce attorney, you are hiring a champion, an advocate, a gladiator whose sole sworn duty is to you and you alone. Their allegiance is 100% to your best interests, and only your best interests. This is a legal and ethical obligation called fiduciary duty. It means they must act with undivided loyalty to you. They are legally forbidden from giving a single piece of advice to your spouse. In fact, their job is to secure the best possible outcome for you, often at the expense of your spouse. Think about that for a second. The entire system is designed by its very nature to be a zero-sum game. For you to win, your spouse has to lose. Your lawyer's job is to maximize your slice of the pie, which inherently means minimizing your spouse's slice. They are trained in an adversarial system of justice. The word adversary literally means opponent or enemy. So from the moment you each hire your own lawyer, you are no longer partners in a shared problem. You are adversaries in a legal dispute. Your lawyer will advise you on how to protect your assets, how to position yourself for the best custody arrangement, and how to leverage your state's laws to your maximum advantage. They will draft aggressive motions, they will conduct invasive discovery, which means demanding financial documents, emails, and text messages, and they will prepare to argue your case before a judge. They are your sword and your shield in the battle of divorce. And if you are dealing with a spouse who is hiding assets, who has a history of abuse, or who is completely unreasonable, having that gladiator in your corner is not just a good idea. It is absolutely essential. But what if your spouse isn't your enemy? What if they are just the person you built a life with, and now you need to figure out how to untangle that life with respect and fairness? What if your primary goal isn't to win, but to solve a problem together? This is where the role of the mediator comes in, and it is a complete 180-degree shift in perspective. A mediator does not work for you. A mediator does not work for your spouse. A mediator works for the agreement. Their allegiance is not to an individual, but to the process of finding a fair, workable, and mutually acceptable resolution. They are a neutral third party. They cannot give legal advice to either of you. They cannot advocate for one side over the other. Their job is to be an impartial facilitator, a guide, a communication coach, and a reality checker for both of you at the same time. Imagine you and your spouse are standing on opposite sides of a wide, treacherous canyon. The canyon represents your disagreements on finances, on parenting, on the future. Hiring lawyers is like each of you hiring an engineering team to build a bridge from your side only. Your team has no interest in what the other team is doing, except to make sure their bridge is longer, stronger, and gets more of the territory. The teams might even start flinging rocks at each other, trying to sabotage the other's construction. It's expensive, it's inefficient, and there's a good chance the two bridges will never meet in the middle. Hiring a mediator, on the other hand, is like both of you jointly hiring one master bridge builder. The builder comes to the middle of the canyon, assesses the entire situation, and helps you both design and build one single solid bridge that connects your two sides. The mediator doesn't care if the first plank comes from your side or your spouse's side. Their only goal is to get the bridge built so that you can both cross over to your new lives, safely and intact. This fundamental difference in role changes everything. In mediation, the focus shifts from me versus you to us versus the problem. The mediator creates a safe, confidential space where you can both speak openly. They help translate for you. When your spouse says, "I have to stay in the house," a lawyer hears a positional demand to fight over. A mediator is trained to ask, "Why is the house important? Is it stability for the kids? Is it the community? Is it a financial concern?" They dig underneath the position to uncover the underlying interest. And once you understand the why behind the what, you suddenly open up a dozen new creative solutions that a courtroom would never even consider. Maybe you don't need the house itself, but you need the kids to stay in the same school district. Maybe your spouse doesn't need to stay forever, but just needs a year to get back on their feet financially. The mediator helps you brainstorm these options. They manage the power dynamics. If one person is a steamroller and the other is passive, the mediator ensures both voices are heard. They are the referee, the guide, and the keeper of the peace, all rolled into one. Their allegiance is to a sane, cost-effective, and dignified outcome for the entire family. So the first key difference is stark. A lawyer's allegiance is to you, their client, in an adversarial battle. A mediator's allegiance is to the agreement, in a collaborative process. One is a warrior for a person, the other is a guardian of the process. Understanding this distinction is the first step in deciding which path is right for you. Your choice here will set the entire tone for your divorce. Will it be a war, or will it be a negotiation? Let's start with that first fundamental difference, the very DNA of each process. This is the difference between an adversarial system and a collaborative one. It's the courtroom versus the conference room. When you hire a divorce lawyer, you are, by definition, entering an adversarial system. The entire structure of the American legal system is built on conflict. There's a plaintiff and a defendant. There are two opposing sides, each armed with a champion, their lawyer, whose sole ethical obligation is to advocate for their client's best interests, and their client's interests alone. Think about that. Your lawyer's job isn't to find a fair middle ground. It's not to preserve your relationship with your soon-to-be ex. It's to win for you. Imagine a couple, let's call them Mark and Sarah. They've been married 12 years, have 2 kids, a house, and a tangled web of finances. The trust has broken down, and they decide to divorce. They each hire a lawyer. Mark sits down in a polished mahogany office. His lawyer, sharp and confident, listens to his story and says, "Okay, Mark, my job is to protect you. We need to secure your access to the children, protect your retirement accounts, and ensure you don't get taken to the cleaners on spousal support. We need to act fast before she starts hiding assets." The conversation is framed as a battle. It's proactive, it's defensive. It's about protecting what's his. Sarah, meanwhile, is in a different office across town, hearing a similar speech. Her lawyer tells her, "Sarah, we need to make sure you get what you're entitled to. He has a bigger income, so we'll fight for fair support. We need to get a forensic accountant to look at his business, make sure he's not hiding money. We need to establish you as the primary caregiver to ensure the children's stability." The language is one of entitlement and defense. From day one, Mark and Sarah are positioned on opposite sides of a battlefield. Their lawyers, doing their jobs correctly, start sending letters and filing motions. They engage in a process called discovery, which sounds collaborative but is often anything but. It's a formal demand for information. Mark's lawyer demands years of Sarah's personal bank statements, emails, text messages. Sarah's lawyer subpoenas Mark's business records and deposes his business partner. Every transaction is scrutinized. Every disagreement from the past is dredged up as potential leverage. Mark and Sarah, who once just wanted to separate their lives, are now locked in a legal war. They're no longer talking to each other. They're speaking through legal documents drafted by professionals trained in conflict. The process itself creates a deeper wound than the initial separation ever did. Now let's look at mediation. It is, by its very nature, a collaborative or non-adversarial process. It's designed to bring people together to solve a shared problem, not to pit them against each other. Let's imagine another couple, David and Lisa. They have a similar situation. Long-term marriage, kids, assets. But they decide to try mediation first. They sit down together in the same room with a neutral third party, the mediator. The mediator's opening statement is completely different from the lawyer's. The mediator might say, "David, Lisa, my role here is not to take sides. I don't represent either of you. I work for both of you to help you have a productive conversation and reach an agreement that you both find acceptable. This is your divorce and you two are the experts on your family. My job is to guide the process, provide information, and help you create a solution that works for you and your children." The entire frame is different. It's not about winning, it's about resolving. The mediator establishes ground rules for communication. No interrupting, no personal attacks. The focus is on the future, not on relitigating the past. When they discuss finances, the mediator doesn't ask, "How can we get you the biggest piece of the pie?" Instead, the mediator asks, "Okay, we have this set of assets and these debts. How can we divide them in a way that allows both of you to land on your feet and start your new lives?" When they discuss the kids, the question isn't who wins custody. It's what parenting plan will be best for your children. How can we create a schedule that maximizes their time with both of you and provides them with stability and love during this transition? For David and Lisa, the process is still painful, still a divorce. But the structure doesn't add fuel to the fire. It provides a container to hold the conflict and guide it toward a solution. They are encouraged to see each other not as enemies, but as co-parents and former partners who need to untangle their lives respectfully. This first difference, adversarial versus collaborative, is the fork in the road. And it leads directly to the second key difference, which is arguably the most important for your sanity, the issue of control. This is the difference between being the driver of your own life and being a passenger in a car driven by someone else. In the traditional lawyer-led adversarial divorce, you give up an immense amount of control. You hand the keys over to your lawyer and the legal system. You are now on a track, a litigation track, with strict rules, procedures, and timelines that you don't understand and cannot change. Your lawyer will advise you, "Don't talk to your spouse directly about the case. Let me handle it." Suddenly, the person you spent a decade or more building a life with is off-limits for direct negotiation. Communication is filtered through two attorneys, like a game of telephone, where messages can be rephrased for legal advantage, often losing their original intent and tone. Mark and Sarah feel this loss of control acutely. Sarah wants to suggest a simple solution for who keeps the family car, but her lawyer advises against it, saying it could be seen as a sign of weakness in the larger negotiation over assets. Mark wants to be flexible on the parenting schedule for a family vacation, but his lawyer files a formal motion with the court instead, turning a simple request into a legal skirmish that costs them both thousands in legal fees. Ultimately, if they cannot agree, and the adversarial process makes agreement incredibly difficult, the final decisions about their lives will be made by a complete stranger, a judge. A judge who has a caseload of hundreds of families, who will spend maybe a few hours hearing the heavily filtered worst version of each other's story presented by their lawyers, and then will issue a binding order. A judge will decide which days of the week Mark gets to see his children. A judge will decide if Sarah has to sell the house she brought her babies home to. A judge will decide how to split the retirement account they dreamed of sharing. They put the most intimate details of their life, their finances, and their children into a public court file and ask a third party to rule on their future. It is the ultimate surrender of personal autonomy. Now, contrast this with mediation. The entire principle of mediation is based on self-determination. You and only you and your spouse are in control. The mediator has zero power to force you to do anything. They cannot make decisions for you. They are a facilitator, a guide, a coach, but you are the players on the field. David and Lisa experienced this firsthand. In their session, they hit a roadblock over the house. Lisa has a deep emotional attachment to it. David is more concerned with the financial reality that neither of them can afford it alone. In a courtroom, a judge would likely just order the house to be sold and the proceeds split. The emotional component would be irrelevant. But in mediation, the mediator can help them explore creative options. The mediator might ask, "Lisa, what does the house represent to you? Is it about stability for the kids? Is it the memories?" And to David, "What is your primary financial goal here? Is it to be free of the mortgage, or to access your share of the equity?" By exploring the interests behind their positions, they can brainstorm. Maybe they agree to a deal where Lisa keeps the house for 3 years until the youngest child finishes middle school, at which point they sell it. Or maybe they find a way for Lisa to buy David out over time. They might come up with a solution a judge would never think of, one that is uniquely tailored to their family's needs. They control the pace of the process. If they need to take a break for a month to cool off or gather financial documents, they can. They control the outcome. They don't sign an agreement until they are both satisfied that it's the best they can achieve. They never set foot in a courtroom. They never hand over their power to a stranger in a black robe. They are the architects of their own future, even as they are dismantling their past. And this brings us to the very first, and arguably the most important key difference between a divorce lawyer and a mediator: their fundamental role. It's the difference between an advocate and a neutral, a champion versus a referee. This isn't just a subtle distinction in job title. It is the philosophical bedrock that dictates every action they take, every piece of advice they give, and the entire emotional temperature of your divorce. Let's start with the lawyer. A divorce lawyer is an advocate. Their role, their sacred duty, is to you and you alone. They are your gladiator in the arena. Their job is not to find a fair middle ground. Their job is not to preserve your relationship with your soon-to-be ex. Their professional and ethical obligation, a concept known as zealous representation, is to fight for the absolute best possible outcome for their client, you. Period. Full stop. Imagine your mark. You and your wife, Sarah, have decided to divorce after 15 years. The house, the kids, the retirement accounts. It's a tangled mess of a shared life. You're hurt, you're scared, and you're worried about your future. You walk into a lawyer's office. The first thing that lawyer does is listen to your story, but they're listening with a specific filter. They are identifying your legal rights, your leverage points, and your spouse's potential weaknesses. You say, "I just want what's fair." The lawyer might nod, but what they're thinking is, what does the law in this state define as fair? And how can I stretch that definition to its absolute limit in my client's favor? You say, "Sarah is a good mother, I don't want to take the kids from her." The lawyer hears, "We need to craft a parenting plan that maximizes Mark's time and minimizes his child support obligation, while still appearing reasonable to a judge." The lawyer becomes your strategic advisor in a conflict. They will tell you what to say and, more importantly, what not to say to your spouse. They will handle all communication, creating a formal, protective barrier between you and Sarah. Every email, every phone call is now filtered through a legal lens. The goal is to build a case, to gather evidence, to position you in the strongest possible light for negotiation, or if necessary, for a courtroom battle. This is a win-lose framework. For you to get more of the marital assets, Sarah must get less. For you to pay less in alimony, Sarah must receive less. It's a zero-sum game. Your lawyer will use legal procedures, like discovery, depositions, and subpoenas, to gain an advantage. They might advise you to file a motion to get temporary exclusive use of the house, putting pressure on Sarah. Not because they are a bad person, but because that is their job. Their job is to use every legal tool in the shed to build a better future for you, even if it comes at the direct expense of your spouse. For many people, this is exactly what they want. They want a protector, a warrior who will go to the mat for them when they feel vulnerable and attacked. They want someone to take charge and fight for their rights when they don't have the strength to do it themselves. Now let's completely switch gears. Let's look at the mediator. A mediator is a neutral. This is the single most critical concept to understand. The mediator does not work for you. The mediator does not work for your spouse. The mediator works for the agreement. They are on the side of a peaceful, mutually acceptable resolution. They are the referee, not the gladiator. Their allegiance is to the process, not to a person. Let's rewind. Imagine Mark and Sarah, with the same tangled mess of a life, decide to try mediation instead. They walk into the mediator's office together. They sit at the same table, maybe for the first time in months, without yelling. The mediator's first job is to establish a safe space. They set ground rules. No interrupting, no personal attacks, a commitment to honest communication. The mediator listens to both of them, but their filter is completely different from the lawyer's. When Mark says, "I just want what's fair," the mediator turns to both of them and asks, "What does fair look like to each of you? Let's write it down. Let's explore the values behind that word." When Sarah says, "I'm terrified I won't be able to support myself," the mediator doesn't see a legal weakness to exploit. They see a core concern that must be addressed for any agreement to be successful. They might say, "Okay, let's talk about that fear. Let's get all the financial documents on the table and build a budget together. Let's look at real numbers and explore options like temporary support or job training." The mediator's role is to facilitate a conversation that the couple can no longer have on their own. They are a communication expert. They reframe inflammatory statements. When Mark says, "You were always irresponsible with money," the mediator might reframe it as, "So Mark, your concern is about financial security and ensuring the assets are managed prudently going forward. Is that right? Sarah, let's talk about your vision for your financial future." They defuse the bombs of past grievances to focus on building a functional future. The mediator doesn't give legal advice or tell either person what to do. They don't have a dog in the fight. They can't. Their neutrality is their superpower. Instead, they provide information. They can explain the general legal framework in their state. They can help brainstorm creative solutions that a court would never even consider. Maybe Sarah keeps the house for a few years until the kids are older, in exchange for Mark getting a larger share of the retirement accounts. Maybe they agree to a flexible child custody schedule that changes with their work seasons, something a judge would rarely order. The framework here is not win-lose. It's about problem solving. The problem isn't Sarah. The problem isn't Mark. The problem is, how do we take this one household, this one set of assets, this one family, and successfully reconfigure it into two separate, stable households in a way that causes the least amount of damage and sets everyone up for success? It's a collaborative win-win, or at least a we can both live with this mindset. The mediator's job is to guide the two architects, Mark and Sarah, as they design their own separate futures, ensuring the foundation is solid for both of them. So you have two completely different starting points. The advocate, the lawyer, is your personal champion in a battle, tasked with getting you the biggest slice of the pie possible. The neutral, the mediator, is a joint guide for both of you, tasked with helping you figure out how to divide the pie yourselves so that nobody feels like they've been cheated. One is a sword and shield you hire for war. The other is a map and compass you share to find a way out of the woods. This fundamental difference in roles, advocate versus neutral, is the first domino. And when it falls, it sets off a chain reaction that completely alters the entire landscape of your divorce. It changes how you communicate, how you make decisions, how much it costs, and how long it takes. And that brings us to the second key difference, which revolves around one of the most powerful and often weaponized elements in any conflict: control of information. In a traditional lawyer-driven divorce, the process for getting that information is called discovery. And the name itself tells you everything you need to know. You have to discover the truth, because the underlying assumption of the entire legal system is that the other person is your adversary, and that they are hiding something from you. It is a system built not on trust, but on mandatory legally enforced verification. It's not a conversation, it's an interrogation. Think of it like a police investigation or a military intelligence operation. Your lawyer's job is to extract information from the other side, using a very specific and very powerful set of legal tools. The first tool is often a set of written questions called interrogatories. These are not casual questions. They are formal legal demands that your spouse must answer in writing, under oath, under penalty of perjury. And they are brutally thorough. We're talking questions like, list every bank account, investment account, or financial instrument you have had an interest in for the past 7 years, including the account number, the institution, and the highest balance during that period. Or, identify every employer you have worked for since the date of your marriage, your title, your dates of employment, and all forms of compensation received, including salary, bonuses, stock options, and expense accounts. Answering these can take dozens, even hundreds of hours. It's an exhaustive and frankly exhausting process designed to leave no stone unturned. Then comes the next tool: the request for production of documents. This is exactly what it sounds like. Your lawyer sends a formal demand for physical proof. Not just a list of bank accounts, but the actual bank statements for all of them for the last 5 years. Not just the name of an employer, but every single pay stub and W-2. They'll ask for tax returns, credit card statements, mortgage applications, retirement account summaries, business profit and loss statements, emails, text messages, anything and everything that could possibly be relevant to the financial state of your marriage. The sheer volume of paper and digital files that this process generates is staggering. It's an avalanche of personal data, and your lawyer and their paralegals will spend countless billable hours sifting through it, looking for inconsistencies, hidden assets, or anything that can be used as leverage. But the most intense, the most infamous tool of discovery is the deposition. If you've ever seen a legal drama on TV, you've seen a version of this. A deposition is a formal, sworn testimony that takes place outside of court, usually in a lawyer's conference room. You, your spouse, both of your lawyers, and a court reporter are all in a room together. 4 hours on end, sometimes for multiple days. The opposing attorney will grill you with questions about every aspect of your life. Your finances, your job, your parenting, your relationships. Every word you say is taken down by the court reporter and becomes a permanent, official transcript that can and will be used against you in court. The deposition is designed for 2 things: to gather information and to test you as a witness. The other lawyer wants to see how you hold up under pressure. Will you get angry? Will you get flustered? Will you contradict yourself? It is a deeply uncomfortable, invasive, and psychologically draining experience. It is pure adversarial combat. And if that's not enough, lawyers can use subpoenas to force third parties, your bank, your employer, your business partner, to turn over your private information directly to them, pulling even more people into the conflict. Now, why does the system work this way? It's not necessarily because all lawyers are aggressive sharks. It's because a lawyer has a professional and ethical duty, a fiduciary duty, to protect their clients' interests at all costs. They operate from a worst-case scenario mindset. They have to assume the other side is hiding a secret crypto wallet or a hidden offshore account, because if they fail to find it, they could be sued for malpractice. The system forces them into the role of a skeptical investigator, because the stakes are too high to simply take someone's word for it. The consequences of this approach are enormous. First, the cost is astronomical. Every interrogatory question written, every document reviewed, every hour spent in a deposition is being billed at hundreds of dollars per hour by both law firms. A single full-day deposition can easily cost $10,000 or more when you add up the time for both attorneys, the court reporter's fees, and the cost of the transcript. The discovery process alone can often be the single most expensive part of a litigated divorce. Second, it takes an incredible amount of time. It can drag on for months, sometimes over a year, creating a war of attrition where the person with the deeper pockets can often try to wear the other person down. And finally, the emotional toll is devastating. The discovery process is fundamentally dehumanizing. It forces you to view the person you built a life with as an enemy combatant. It destroys any remaining goodwill and makes co-parenting and future cooperation almost impossible. It often inflicts a type of trauma that people carry with them for years. Now, let's pivot and look at how a mediator handles information. It is a night and day difference. Where the lawyer's approach is defined by adversarial discovery, the mediator's approach is defined by collaborative transparency. Instead of assuming the other person is hiding something, mediation starts with the assumption that both people are willing to be open and honest to reach a fair agreement. It doesn't rely on blind trust, but it is built on a foundation of good faith participation. There are no interrogatories, no depositions, no subpoenas. Instead, there is a simple voluntary exchange of information. Here's how it typically works. The mediator will provide both of you with a checklist of standard financial documents you'll need to make informed decisions. Things like the last 3 years of tax returns, recent pay stubs, statements for all bank, retirement and investment accounts, a mortgage statement, and credit card debt summaries. You and your spouse agree to gather these documents and share them openly with each other and the mediator. The entire dynamic is different. It's not a lawyer demanding documents under threat of legal action. It's a mediator saying, okay, for us to have a productive discussion about dividing the retirement accounts, we all need to see the most recent statements. Sarah, can you bring your 401k statement to our next session? And Mark, can you bring the statement for your pension? The information isn't a weapon to be seized. It's a tool to be used for joint problem solving. The mediator's role here is crucial. They act as a neutral facilitator. They help you organize the information, often putting it all into a single shared spreadsheet that clearly lists all the assets and debts. This creates a unified financial picture that you both look at together. This is the polar opposite of the lawyer's approach, where each side creates their own separate, secret file on the other, each with their own version of the truth. In mediation, you're literally and figuratively on the same page. But this raises the big, obvious question. What if my spouse lies? What if they have a secret bank account and just forget to disclose it? This is a valid and critical concern. Mediation requires that baseline of good faith. If you have concrete evidence that your spouse is actively hiding significant assets and refusing to be honest, then mediation may not be the right path for you. In that case, you might need the power of a lawyer and the legal tools of discovery to unearth that information. However, the mediation process isn't without its own safeguards. First, as part of the process, you will both sign a sworn financial statement, under penalty of perjury, attesting that you have disclosed everything fully and truthfully. Second, and most importantly, the final settlement agreement that you sign will contain clauses stating that it is based on this full and fair disclosure. If you later discover that your ex-spouse hid an asset, that lie constitutes fraud, and you can take them back to court to have the entire agreement thrown out and potentially be awarded a larger share of the assets, plus attorney's fees. The consequences for hiding information are severe, and a good mediator will make sure both parties understand those risks from the very beginning. So let's sum up this crucial difference. The lawyer-driven discovery process is a system designed for mistrust. It is legally powerful and incredibly thorough, but it is also a sledgehammer. It's expensive, it's slow, and it is emotionally destructive. It treats information as a weapon. The mediation process, on the other hand, is a system designed for cooperation. It is faster, dramatically less expensive, and preserves the dignity of the family. It treats information as a shared tool. To put it in a final analogy, legal discovery is like two rival nations on the brink of war, each using spies and surveillance to build a secret dossier on the other, always assuming the worst. Mediation is like two business partners sitting down in a boardroom, opening their financial ledgers on the table, and figuring out the best way to dissolve their partnership. The fundamental goal is different, so the entire approach to information is different. This fundamental difference in how information is handled leads directly to our third key distinction, and it's perhaps the most important one of all. It's about who actually holds the power. Who gets to make the final life-altering decisions about your money, your home, and your children? The answer might surprise you, and it completely changes the game. In a traditional, lawyer-driven divorce that ends up in court, the ultimate power rests with one person. And it's not you. And it's not your spouse. It's a judge. A complete stranger wearing a black robe, who has a caseload of dozens, if not hundreds of other families, all with their own complicated stories. This person will likely spend, at most, a few hours getting to know the intimate details of your life, your finances, your parenting style, your history, your hopes for the future, before they make binding, life-altering decisions. Think about that for a second. The person who decides when you see your children, whether you can keep the home you've lived in for 20 years, and how much of your own hard-earned money you have to give to your ex-spouse, is someone who doesn't know you from Adam. They'll read legal briefs, which are documents written by your lawyers designed to paint you in the best possible light, and your spouse in the worst. They'll hear arguments in a formal, intimidating courtroom setting. They are bound by strict legal statutes and precedents that may have very little to do with the unique reality of your family. They're trying to apply a one-size-fits-all legal ruler to a situation that is deeply personal and has a million different shades of gray. The judge's job is not to find the perfect solution for your family. Their job is to apply the law and end the conflict so they can move on to the next case on their docket. And once they make that ruling, that's it. It becomes a court order, a legally enforceable command. You lose your autonomy. You lose your say. You have handed the pen that writes the next chapter of your life over to a stranger. Let's imagine a couple, we'll call them David and Jessica. They have 2 kids, ages 8 and 11. They're both decent people who love their children more than anything, but their marriage has fallen apart. They can't agree on a parenting schedule. David works non-traditional hours as a paramedic, with rotating shifts. Jessica is a teacher with a very structured Monday to Friday schedule. They hire lawyers. The lawyers do what lawyers are trained to do. They advocate aggressively. David's lawyer argues that a week-on, week-off schedule is fairest. Jessica's lawyer argues that the kids need the stability of being with their mother during the school week. The communication breaks down completely. They end up in front of a judge. The judge is overworked. It's 3 p.m. on a Friday. He's already heard 3 other contentious cases that day. He looks at David and Jessica's file for maybe 20 minutes. He hears 10 minutes of argument from each lawyer. He doesn't have time to dig into the nuances of David's rotating shift schedule or the kids' after-school activities. He sees 2 parents who can't agree, so he does what's easiest. He imposes a standard, boilerplate custody order from his state's family code. He gives them a rigid 50-50 schedule that alternates weeks. On paper, it looks fair. In reality, it's a disaster. David has to constantly find last-minute childcare or trade shifts because his work schedule doesn't align with the court-ordered parenting time. Jessica is frustrated because she can't get David to agree to a simple swap when a school event falls on his week. The kids are stressed, constantly being shuffled back and forth without a predictable rhythm. The court order, which was supposed to solve their problem, has actually become the source of their new ongoing conflict. David and Jessica both feel like they lost, but more importantly, they lost control. The system took their power and gave them back a solution that didn't work for anyone. Now let's flip the script. Let's look at mediation. In mediation, the power structure is turned completely upside down. The most powerful people in the room are you and your spouse. The mediator has 0 power to make a decision for you. Let me repeat that because it is the single most important thing to understand. A mediator cannot force you to do anything. They are not a judge. They are a facilitator, a guide, a coach. Their job is to create a safe and structured environment where the 2 of you can make your own decisions. You are the experts on your own lives. You know your finances better than any judge ever could. You know your children's quirks, their fears, and their needs. You know the realities of your work schedules and your budgets. In mediation, you take that expertise and you use it to build your own agreement from the ground up. The mediator helps you communicate, brainstorms options you might not have thought of, and provides information about the law so you can make informed choices. But every single decision, from who gets the frequent flyer miles to how you'll handle a child's medical emergency, is made by you and your spouse. Let's rewind and send David and Jessica to a mediator instead. They sit in a conference room, not a courtroom. The mediator helps them put their emotions aside for a moment and focus on the problem like a puzzle they need to solve together. How to create a parenting plan that works for the kids and for their unique schedules. They pull out a calendar. David maps out his rotating shift schedule for the next 3 months. Jessica lays out the school calendar and the kids' soccer schedule. The mediator asks questions. What's most important to you, David, about your time with the kids? Jessica, what is your biggest concern about a schedule that isn't the same every single week? Instead of arguing about legal positions, they start talking about practical realities. After a couple of sessions, they design a creative solution. They create a 2-week rotating schedule that mirrors David's work shifts, but they build in a consistent Sunday evening dinner where they all sit down together, no matter whose time it is, to create stability for the kids. They agree on a shared digital calendar to manage appointments. They even build in a clause about how they will handle schedule changes, agreeing to give each other 48 hours notice for any non-emergency request. Do you see the difference? In this scenario, David and Jessica kept the power. They used their expert knowledge of their own family to create a custom-fit solution. They didn't get a boilerplate order from a stranger. They co-authored a detailed, practical plan for their future. They walked out of that process not as winner and loser, but as co-parents who solved a difficult problem together. They are far more likely to stick to this plan because they created it themselves. It's a plan born of empowerment, not of surrender. This is the fundamental difference. With lawyers in court, you are asking a system to impose an answer upon you. With mediation, you are empowering yourselves to create your own answer. It's a choice between handing over control and retaining your own authority over the future of your own life. And this brings us to our 3rd key difference, and for many people, it's the one that hits home the hardest. It's the difference in cost. And I'm not just talking about money, Although we will absolutely break down the staggering financial gap between these two paths. I'm talking about the total cost, the cost in dollars, the cost in time, and the cost in your emotional well-being. Because a divorce will exact a price in all three of these currencies. The question is, how much are you willing to pay? Let's start with the most tangible, the financial cost. When you hire a divorce lawyer, you are typically entering the world of the billable hour. The first thing you'll likely do is pay something called a retainer. Think of this as a down payment, a lump sum of money, often $5,000, $10,000, maybe $15,000, that your lawyer will bill against. Every phone call you make to them, every email you send, every document they draft, every moment they spend thinking about your case. It's all tracked, usually in 6-minute increments, and deducted from that retainer. When the retainer runs out, you replenish it. You pay another lump sum, and the meter starts running again. Now, understand the incentive structure here. In an adversarial system, the longer the conflict goes on, the more motions are filed, the more back and forth there is, the more billable hours are generated. I am not saying lawyers intentionally drag things out. Their duty is to advocate for you. But the system itself is built on conflict, and conflict is expensive. You're not just paying for your lawyer's time. You're paying for filing fees with the court. You might need a forensic accountant to trace assets, which can cost tens of thousands of dollars. You might need a business valuator, a real estate appraiser, or a child custody evaluator. These are all experts who bill their own significant hourly rates. You're paying for depositions, where your lawyer questions your spouse under oath, and their lawyer questions you, all with a court reporter transcribing every word at a per-page cost. Let's imagine a couple, we'll call them David and Jessica. They have 2 kids in a house. They disagree on how much spousal support is fair and what the parenting schedule should look like. They each hire a lawyer. Jessica's lawyer sends a formal request for financial documents. David's lawyer finds it too broad in objects. They file motions with the court to argue about what documents need to be produced. That's 2 lawyers billing for hours of drafting, filing, and preparing. Then they argue about a temporary parenting schedule. Another motion. Another court hearing. 2 more lawyers billing for hours of prep and court time. A simple email from David to Jessica about a school play gets forwarded to the lawyers. The lawyers then exchange emails with each other, strategizing, posturing, and of course billing for that time. What could have been a 5-minute conversation between the couple becomes a $500 exchange between their legal teams. This isn't an exaggeration. It is the daily reality of a litigated divorce. The average cost of a divorce that goes to trial in the United States can easily exceed $100,000. Even for cases that settle before a trial, it's not uncommon for each person to spend $20,000 to $50,000 or more. You are essentially funding a war with your own family's assets. Now let's pivot and look at the cost of mediation. The entire financial model is different. A mediator is a neutral third party. You don't have 2 opposing teams. You have one guide. Most mediators charge a much lower hourly rate than a litigation attorney, and critically, that single cost is typically split between the 2 of you. Some mediators even offer flat fee packages for the entire process, so you know the total cost up front. There are no dueling experts. If an expert is needed, like a house appraiser, you both agree on one neutral expert and share the cost. There are no court motions, no depositions, no formal discovery battles. The process is designed for efficiency and resolution, not conflict. Let's put David and Jessica into mediation. In their first session, the mediator helps them create a list of all the issues they need to resolve. They disagree on spousal support. Instead of filing motions, the mediator educates them on state guidelines, runs different financial scenarios on a screen for them to see, and facilitates a conversation about their budgets and future needs. They disagree on the parenting schedule. The mediator doesn't encourage them to fight for maximum custody. Instead, they facilitate a discussion about the children's needs, their school schedules, and what's realistically best for their family. They work together to create a plan. The entire process might take 5 or 6 2-hour sessions. The total cost might be somewhere between $5,000 and $10,000. Asterisk total asterisk, not per person. That is a fraction, often less than 10%, of the cost of a litigated divorce. You are preserving your family's assets for your family's future, for your children's college funds, for your own retirement, instead of liquidating them to pay for the process of splitting them. But the price tag is only part of the story. Let's talk about the cost of time. The court system is overburdened. A litigated divorce moves at the pace of the court's calendar, not your family's needs. From the initial filing to the final judgment, It can easily take a year, 2 years, or even longer if the case is complex or high conflict. For those 2 years, your life is in a state of suspended animation. You can't make major financial decisions. You can't definitively plan your future. You live with the constant, low-grade stress of deadlines, hearings, and the looming uncertainty of a judge's decision. It is an exhausting marathon of anxiety. Mediation, on the other hand, moves at your pace. You and your spouse, with the mediator's help, set the schedule. You can meet weekly, bi-weekly, whatever works for you. A motivated couple can work through all their issues and have a signed agreement in a matter of months, sometimes even weeks. This allows you to close one chapter of your life and begin the next with clarity and speed. It gives you back your future sooner. And that brings us to the final and perhaps most important cost, the emotional toll. A litigated divorce is, by design, an adversarial process. It frames you and your spouse as opponents. To win your case, your lawyer may need to paint the other person in the worst possible light. Every weakness is exploited. Every mistake is magnified. You read sworn declarations filled with accusations against you, and you are forced to respond in kind. The process can systematically destroy any remaining goodwill or respect between two people who once built a life together. It forces you into a battle mindset, where compromise is seen as weakness and aggression is rewarded. The stress, the anger, the fear, it's immense. And who pays the highest price for this emotional warfare? The children. They are caught in the middle of a conflict they cannot understand, forced to bear the weight of their parents' hostility. The damage from a high-conflict divorce can last a lifetime. Mediation is engineered to do the exact opposite. Its primary goal is to de-escalate conflict. It takes place in a private, confidential setting, not a public courtroom. The mediator's job is to create a safe space for difficult conversations, to help you listen and be heard. The focus is not on dredging up the past to assign blame, but on building a functional future. For parents, this is everything. Mediation doesn't just help you create a parenting plan. It models the very communication and problem-solving skills you will need to be effective co-parents for years to come. It preserves your ability to sit together at your child's graduation, to celebrate their wedding, to be grandparents together. It chooses to protect the future of your family, even as the structure of your marriage changes. So when you weigh the cost, you have to look at the full balance sheet. Is it worth spending an extra $50,000, $100,000, or $200,000 to have a lawyer fight for you? Is it worth spending 2 years of your life in a state of stressful limbo? Is it worth sacrificing your future co-parenting relationship and your family's emotional health? For some, in very specific situations involving abuse, hidden assets, or a complete power imbalance, the protection of the court and a zealous advocate may be necessary. But for the vast majority of couples, the true cost of litigation far outweighs any perceived benefit. The choice you make isn't just about how you get divorced. It's about what you'll have left, financially, temporally, and emotionally, when it's all over. And this directly impacts the final outcome, which leads us to our fourth key difference: the nature of the solution itself. The solution from a divorce lawyer in a courtroom is a judgment. The solution from a mediator is an agreement. And while those two words might sound similar, they represent two entirely different universes of outcome. A court judgment is like being handed a standard issue, one-size-fits-all uniform. It's made of rigid, durable material, it follows a strict set of regulations, and it will, technically, cover you. But it won't fit your unique shape. It'll be too tight in some places, too loose in others. It won't account for the way you move, the work you do, or the person you are. You are forced to conform to it. A mediated agreement, on the other hand, is like a custom-tailored suit. It's built from the ground up, thread by thread, with your specific measurements, your needs, and your future in mind. It moves with you. It's designed not just to be legally sound, but to be livable. Let's break down what this really means. When a case goes to court, a judge, who is a stranger to you and your family, listens to two opposing stories. They are presented with evidence, bank statements, emails, testimony, which is a filtered, often weaponized snapshot of your life. The judge's job is not to find the perfect solution for your family. Their job is to apply the law of the state to the facts presented. They operate within a very strict, very narrow framework. They have a set of legal tools, statutes on property division, formulas for child support, guidelines for custody, and they use them to render a decision. They are a surgeon with a very specific set of scalpels, and they will make an incision based on the textbook, whether or not that's what the patient truly needs to heal. Consider the story of Mark and Sarah. They couldn't agree on anything, so their lawyers took it all the way to trial. One of the biggest points of contention was child support. Mark was a freelance web developer, and the year before the divorce he had landed 2 massive contracts. His income was the highest it had ever been. Sarah's lawyer presented this as evidence of his earning capacity. Mark's lawyer argued it was an anomaly, showing years of much lower, inconsistent income. The judge, bound by the evidence and the state's formula, looked at the most recent tax return and issued an order based on that peak income. The judgment was legally sound. It was defensible, but it was completely detached from reality. For the next 6 months, Mark struggled. He didn't land any big contracts. He was making less than a third of what he made the previous year, yet he was legally obligated to pay support based on an income he no longer had. He started draining his savings, then his retirement accounts, just to avoid being in contempt of court. The financial pressure was immense, creating so much stress that his work suffered even more. The court's solution had created a new, more desperate problem. It wasn't a solution for the family. It was a legally correct calculation that was functionally bankrupting one of the parents, which in the long run helps no one, especially not the children. The one-size-fits-all uniform was choking him. Now let's imagine how mediation would have handled this. A mediator isn't a judge. They don't impose a decision. They facilitate a conversation. They would have looked at Mark's income not as a single number on a tax return, but as a dynamic reality. They would have asked questions like, "Mark, what does a typical year look like for you? What's a good month and what's a slow month? Sarah, what are the core, non-negotiable expenses for the kids each month? What's the baseline we need to cover?" From that conversation, they could have built a creative, custom-tailored solution. Perhaps they would have agreed to a lower base amount of monthly child support that Mark could reliably pay even in a slow month. Then they could have added a clause for a true-up payment. Maybe once a quarter they would sit down, look at Mark's actual earnings, and if his income exceeded a certain threshold, he would pay an additional pre-agreed-upon percentage to Sarah. This solution protects everyone. Sarah and the kids get the stability of a consistent base payment, but they also get to share in the upside when Mark does well. Mark isn't crushed by an unrealistic obligation during lean times, which allows him the mental and financial space to actually grow his business. This is a solution a judge would likely never order. It's too nuanced, too complex for the blunt instrument of a court order. But it's the kind of solution that is born every single day in mediation rooms across the country. Mediation allows you to move beyond rigid legal formulas and into the realm of what actually works for your life. This creativity extends to everything. Let's talk about the family home. In court, a judge typically has 2 options: order the house to be sold and the proceeds divided, or have one spouse buy out the other. But what if neither of those options is ideal? What if the housing market is terrible? What if the kids are in their last year of high school and you want to give them stability until they graduate? In mediation, you can invent a third option. You could agree to keep the house and co-own it for 2 more years. You could create a detailed agreement on who pays the mortgage, who is responsible for repairs, and what the exact conditions for the future sale will be. You can design a plan that prioritizes the children's emotional well-being over a swift, clean financial transaction. Or consider the parenting plan. A judge will issue a custody schedule. It will say, Parent A has the children on these days, and Parent B has them on these days. It will be legally enforceable. But a mediated parenting plan is a living, breathing document. It's not just a schedule. It's a philosophy for co-parenting. You can discuss and agree upon things a judge would never touch. How will we handle discipline? What are our shared values on screen time? How will we introduce new romantic partners to the children? How will we make decisions together about their education or healthcare? You are literally creating a business plan for the new, restructured business of co-parenting your children. The agreement becomes a manual you built together, a guidepost you can return to when you inevitably disagree down the road. This leads to the most profound difference in the nature of the solution: the psychological impact of ownership. When a judge issues an order, it is something that is done to you. You are a passive recipient of a decision, and if you don't like that decision, if you feel you lost, that sense of injustice can fester for years. Every co-parenting exchange, every financial transaction, becomes tainted with resentment. You comply with the order because you have to, because the threat of legal action hangs over your head. It's compliance born of fear. A mediated agreement is something you do for yourselves. You are the active architects of your own future. Even if you have to make difficult compromises, even if you don't get everything you want, you have a voice. You have agency. You participated in the creation of the final document. This fosters a sense of ownership and buy-in that is impossible to achieve in a courtroom. You are far more likely to voluntarily comply with an agreement you helped create. It's compliance born of integrity. You gave your word. This fundamental shift in mindset, from adversarial opponents to collaborative problem solvers, doesn't just end the marriage. It lays the groundwork for a peaceful, functional, and respectful co-parenting relationship for the next 5, 10, or 20 years. Ultimately, the nature of the solution you seek should define the path you take. Are you looking for a legally correct answer imposed by the system, a one-size-fits-all uniform that might chafe and restrict you for years to come? Or are you looking for a functionally effective solution that you design yourselves, one that is tailored to the unique realities of your family and built to last? The first is a judgment. The second is an agreement. The difference between them is the difference between an ending and a new beginning. This choice between an imposed outcome and a co-created one also fundamentally alters the role of communication, which brings us to our fifth and final key difference: the flow of information. In an adversarial legal system, communication is structured like a fortress. It's a hub-and-spoke model, and you are not the hub. Your lawyer is. Information flows from you to your lawyer. Your lawyer then processes, filters, and translates that information into a legal strategy. They then communicate that strategy to the opposing lawyer. That lawyer then processes, filters, and interprets that message for their client, your spouse. Finally, your spouse reacts, and the entire convoluted process repeats in reverse. Every single message, every question, every offer has to travel through 4 separate checkpoints. Think about the children's game of telephone. The first person whispers a simple sentence, and by the time it gets to the end of the line, it's a completely distorted, nonsensical mess. Now imagine that game being played not with a silly sentence, but with the most sensitive, emotionally charged details of your life. And instead of kids whispering, you have highly trained legal professionals whose primary duty is to frame every single word to gain a strategic advantage for their client. It's not just distortion, it's weaponization. A simple, heartfelt question like, "I'm worried about being able to afford the mortgage on my own. Can we discuss options?" gets translated by your lawyer into a formal legal document. It might be phrased as, "Pursuant to the division of marital assets, my client formally requests a proposal regarding the disposition of the marital home, inclusive of all financial liabilities, within 10 business days." When your spouse receives that, they don't hear your anxiety. They hear a cold, aggressive demand. They don't see a partner in a tough situation. They see an opponent making a move on the chessboard. Their natural reaction? To call their own lawyer and say, "They're coming after the house. Fight back." This isn't because the lawyers are bad people. It's because the system is designed this way. The lawyer's job is to be a shield and a sword. They shield you from saying something that could legally harm your case, and they use the information you give them as a sword to advocate for your position. This indirect, filtered communication inevitably creates suspicion. What aren't they telling me? What is my spouse's lawyer advising them? Why did it take a week to get an answer to a simple question? The system itself breeds distrust and paranoia, turning solvable misunderstandings into full-blown battles. You lose the ability to speak human to human. Instead, your avatars fight in an arena of motions and filings, and you just get the bill. Mediation, on the other hand, dismantles the fortress and replaces it with a round table. The flow of information is direct, immediate, and transparent. You are in the same room, physically or virtually, speaking directly to your spouse. The mediator isn't a filter or a mouthpiece. They are a facilitator, a combination of translator and air traffic controller. Their job is not to speak for you, but to help you speak more effectively to each other. When communication breaks down, as it so often does in a divorce, the mediator steps in. They don't take the message and pass it along. They help you rephrase it. So, "You've always been irresponsible with money and I don't trust you," becomes, "It sounds like financial security is a major concern for you. Let's talk about creating a clear, predictable budget for the kids' expenses that you both feel comfortable with." The mediator translates the accusation into an underlying interest. They absorb the anger and reflect back the need. This single function is profoundly powerful. It allows you to hear the real concern behind the angry words, a concern you might even share. In this model, there is no game of telephone. You hear the tone of your spouse's voice. You see their body language. You can ask for clarification in real time. "What do you mean by that?" Isn't a question you text your lawyer to ask their lawyer. It's a question you ask directly right then and there. This directness incinerates ambiguity. It forces you both to confront the actual issues instead of fighting shadows and assumptions. Information is no longer a weapon to be hoarded or a piece of a legal strategy. It becomes a shared tool. Financial documents aren't produced as a result of a threatening request for production. They're brought to the table as necessary data to solve a shared problem: how to fairly divide your assets and create two stable households. This difference in communication flow has a staggering psychological impact that lasts for years after the divorce is finalized. The legal hub-and-spoke model trains your brain to see your spouse as an adversary. For months or even years, every interaction is filtered through a lens of conflict. Your lawyer, your advocate, is constantly pointing out their weaknesses, their potential threats, their untrustworthiness. By the time the divorce is over, you've been deeply conditioned to view your co-parent as the enemy. And then the system says, okay, you're divorced. Now go co-parent effectively for the next 18 years. It's a psychological whiplash that sets families up for a future of conflict. The mediation roundtable model does the opposite. It trains you to see your spouse as a problem-solving partner. Yes, the marriage is ending, but you have a shared project to untangle your lives respectfully and efficiently. The process forces you, under the guidance of a neutral professional, to practice the very communication skills you will need to co-parent effectively. It separates the spousal relationship, which is ending, from the co-parenting relationship, which is permanent. By learning to communicate directly and productively about the divorce, you're actually laying the foundation for a stable, low-conflict future for your children. Imagine two business partners, Alex and Ben, dissolving their small but successful company. In the lawyer-led scenario, Alex is worried Ben might try to poach their biggest client before the split is official. He tells his lawyer this. The lawyer, doing his job, immediately sends a cease and desist letter to Ben's lawyer, threatening a lawsuit for tortious interference if Ben contacts the client. Ben gets this letter and is floored. He had no intention of poaching the client. He was just planning to call them to ensure a smooth transition. Feeling attacked and falsely accused, Ben tells his lawyer, fine. If that's how he wants to play it, let's do a full forensic audit of Alex's expense reports for the last 5 years. I bet he's been padding them. A simple unvoiced fear has now spiraled into two expensive, time-consuming, and relationship-destroying legal battles. Now let's put Alex and Ben in mediation. The mediator asks, what are your biggest concerns as we move through this process? Alex says, honestly, I'm a little anxious about our top client. I want to make sure we handle that transition in a way that's fair to both of us and doesn't spook them. Ben, hearing this directly, immediately understands. He says, that's a great point. I was thinking the same thing. How about we draft a joint email to them together, letting them know about the change and assuring them that we're working together to make it seamless. In 10 minutes, with direct communication, they not only solve the problem but reinforce their mutual respect and trust. The flow of information is not a minor technical detail. It is the architecture of your divorce. One path builds walls, moats, and defensive towers, ensuring that by the end, you are strangers living in separate, fortified castles. The other path builds a bridge, a difficult but necessary bridge, that allows you to walk away from the marriage without having to burn the entire landscape behind you. We've now explored the core identity, the cost structure, the role of control, the ultimate goal, and the flow of information. We've seen how these two paths, the lawyer-led and the mediator-led, diverge at every critical juncture. But knowing the map is only half the battle. The crucial question that remains is how to choose the right path for your own personal journey. Because the answer isn't the same for everyone. So let's build that compass. Let's forge the key that unlocks the right door for you. This isn't about flipping a coin. It's about a clear-eyed, honest assessment of your unique situation. Think of this as your personal decision-making matrix. We're going to walk through 4 critical areas of your life and your separation. And as we go, I want you to be brutally honest with yourself. There are no right or wrong answers here, only your truth. And that truth will point you toward your path. First, and most importantly, the state of your communication. This is the bedrock upon which everything else is built. Ask yourself this. Can you and your soon-to-be ex sit in the same room, look each other in the eye, and discuss the most sensitive topics, your children, your money, your future, without the conversation catching fire? I'm not asking if it's comfortable. It won't be. I'm not asking if you're friends. You're likely not. I'm asking if there is a fundamental baseline level of respect that still exists. Can you disagree without being disagreeable? Can you listen to a proposal you hate, and instead of screaming say, "I hear what you're saying but I see it differently"? If your answer is a tentative yes. If you believe that with a neutral third party guiding the conversation, you could productively work through the issues, then the door to mediation is wide open. This is the ideal environment for a mediator to thrive. They can work with that flicker of civility and fan it into a functional flame of negotiation. But what if your answer is an immediate, gut-wrenching no? What if the very thought of being in a room with them makes your stomach clench? What if every single text message, every email, is a minefield of passive aggression, blame, and old wounds? If communication has completely and utterly broken down, if it's toxic, then trying to force mediation is like trying to build a house on quicksand. It will collapse. In this scenario, a lawyer isn't just an option. They're a necessity. They become your shield and your spokesperson. They filter the venom. They translate the hostile, emotionally charged attacks into the sterile, objective language of the law. They create a buffer zone so that you don't have to absorb the full force of the conflict, allowing you to make decisions from a place of relative calm, rather than constant reaction. If communication is impossible, you need an intermediary who speaks the language of the court, and that's a lawyer. Second, let's talk about the power balance. This is a subtle but profoundly important factor. A successful mediation relies on the assumption that two people are entering the room as relative equals, capable of advocating for their own needs and interests. But marriage and divorce is rarely that simple. A power imbalance can take many forms. The most obvious is financial. Did one person earn all the money while the other stayed home? Does one person have a degree in finance while the other has trouble balancing a checkbook? If one of you understands the intricate details of your investments, debts, and assets, and the other doesn't even have the password to the online banking portal, you are not on a level playing field. But it goes deeper than money. It can be emotional. Is there a history of one person being the dominant personality, the decision maker, while the other has always been more passive or conflict avoidant? Do you find yourself agreeing to things just to keep the peace? Do you feel intimidated, easily manipulated, or emotionally steamrolled by your spouse? If you read that and feel a nod of recognition in your gut, be very, very careful with mediation. A skilled mediator will try to balance the power in the room, but they are not your advocate. They cannot give you advice. A manipulative or dominant spouse can, sometimes unintentionally, sometimes with full intent, steer the mediation in their favor. The more passive spouse might walk away with an agreement that feels okay in the moment, only to realize months later that they've been taken advantage of. This is where a lawyer acts as an equalizer. Their entire job is to be your strength when you feel weak. They understand the financial complexities you don't. They can stand up to the intimidating personality you can't. They aren't susceptible to the years of emotional history that might cause you to fold. If you feel like you are at a disadvantage, financially, educationally, or emotionally, a lawyer doesn't just level the playing field. They build you a fortress on it. Third on our matrix, the complexity of your estate. Let's be blunt. Some divorces are just more complicated than others. If you were married for 3 years, you both have simple W-2 jobs, you rent your apartment, and you have no children, your financial picture is likely a straightforward snapshot. It's a case that is perfectly suited for mediation. A mediator can help you divide your bank accounts and personal property efficiently and cost-effectively. But what if your picture is not a snapshot, but a sprawling, intricate mural? What if you own a family business that needs to be valued? What if one of you has a complex executive compensation package with unvested stock options and deferred bonuses? What if you own 3 rental properties, a complicated investment portfolio, and a pension that's subject to division? Or, and this is the big one, what if you suspect, even just have a nagging feeling that your spouse is hiding assets? Maybe they've been taking mysterious business trips, or you've noticed money moving around in ways you don't understand. In these high complexity or high suspicion scenarios, the tools of a lawyer are indispensable. A mediator cannot issue a subpoena for bank records from a secret account. A mediator cannot force a third-party valuation of a business whose owner is being uncooperative. A mediator cannot conduct a formal deposition to question your spouse under oath about their finances. A lawyer can do all of these things. This is called discovery, and it's the legal process of compelling the full disclosure of information. When the finances are tangled or there's a whiff of dishonesty, you don't need a facilitator. You need an investigator. You need a legal team that can bring in forensic accountants to trace every single dollar and ensure you are negotiating with a full and complete picture of the marital estate. Trying to mediate a complex or shady financial situation is like trying to perform surgery in the dark. You need a lawyer to turn on the lights. Finally, the fourth and most personal question. What is your emotional and physical safety status? Divorce is a trauma. It is listed as one of the most stressful life events a person can endure, second only to the death of a loved one. You are not operating at 100%. You are likely exhausted, grieving, angry, and scared. You need to ask yourself honestly, am I in any state to make rational, life-altering decisions for myself right now? Can I sit at a table and negotiate the terms of my future? Or am I so overwhelmed that I would agree to anything just to make it stop? If you are feeling completely broken and unable to function, it is not a sign of weakness to hire a lawyer. It's a sign of wisdom. A lawyer acts as your surrogate brain. They manage the deadlines, file the paperwork, and handle the aggressive communication so that you have the space to breathe and to heal. They are the calm, strategic mind when yours is a whirlwind of pain. And this leads to the most critical point of all. If your physical or emotional safety is at risk, the choice is made for you. If there is any history of domestic violence, substance abuse, uncontrolled mental illness, or any form of abuse, verbal, emotional, or physical, mediation is not an option. It is dangerous. Mediation rooms are not equipped to protect a vulnerable party from their abuser. The power imbalance is absolute. In these situations, you need the full protection of the legal system. You need a lawyer who can go to court immediately and ask a judge for a restraining order. You need an advocate whose primary non-negotiable duty is to keep you and your children safe. This is not a gray area. This is a bright red line. Your safety is paramount, and the legal system, through a dedicated attorney, is the mechanism designed to protect it. So take a moment. Think through these four pillars: your communication, the power balance, the financial complexity, and your emotional well-being. Where do you land? Be honest. This self-assessment is the most valuable gift you can give yourself at the start of this process. It will guide you away from a path that could lead to regret and toward the one that offers you the best chance at a fair and stable future. But what if you find yourself straddling the line? What if your communication is okay, but your finances are complex? What if you feel emotionally strong but know there's a power imbalance? It can feel like you're stuck between two imperfect options. But you're not. There's a third way. A hybrid approach that most people have never even heard of, one that can give you the best of both worlds: the cost savings of mediation with the protection of a lawyer. And understanding how that works is the final piece of this puzzle. This hybrid approach is called attorney-assisted mediation, or sometimes, mediation with review counsel. And it is, without a doubt, the most powerful and underutilized tool in the entire landscape of American divorce. It's the secret menu item that combines the best ingredients from both sides of the kitchen. So what is it? Imagine the mediation process we've already discussed. You and your spouse sit down with one neutral mediator, whose job is to facilitate a conversation and help you find common ground. The cost is shared, the environment is collaborative, and you two are in the driver's seat. All of the benefits of mediation are there. But here's the game-changing twist. Behind the scenes, you each have your own independent lawyer. Now, these aren't the gladiator lawyers from the courtroom. They don't typically attend the mediation sessions. They aren't there to yell and posture. Think of them instead as your personal legal coach, your behind-the-scenes strategist. Their job is to protect you, to advise you, and to ensure that the collaborative process doesn't lead you into a terrible deal. Here's how it works in practice. You and your spouse might have a 2-hour mediation session where you discuss splitting up your assets. The mediator helps you create a list and you come up with a proposal that seems fair on the surface. You agree to split the house equity, the 401k, and the savings account right down the middle 50-50. Sounds perfectly equitable. But then, before you agree to anything, you take a break. You email that proposal to your consulting attorney. The next day, you have a 1-hour call. Your attorney looks at the proposal and says, "Okay, on the surface 50-50 sounds fair. But did you consider that the $300,000 in the 401k is pre-tax money? When you withdraw it in retirement, you'll owe taxes, so it's really only worth about $220,000 in today's money. The $300,000 of equity in the house, however, is post-tax. It's real cash. So a 50-50 split of these two assets is not actually a 50-50 split in value. Let's run the numbers on a different scenario that accounts for the tax implications." Boom! In 1 hour, for the cost of a single billable hour, your attorney has just saved you potentially $40,000 or $50,000. Not by fighting, not by filing motions, but by providing critical, expert advice that the neutral mediator is legally forbidden from giving you. You now go back to the next mediation session armed with this knowledge. You can say, after reviewing the proposal, I have a better understanding of the tax consequences. I'd like to discuss a way to rebalance the asset split to make it truly equal in post-tax value. You haven't accused anyone of being unfair. You haven't started a fight. You've simply introduced new factual information into the negotiation, allowing you both to make a more informed, and therefore, a more fair and lasting decision. Your spouse, in turn, can consult with their own attorney to verify the information and discuss their own interests. This hybrid model directly solves the 5 key differences we've been talking about, but in a way that gives you the best of all possible outcomes. First, the role of the professional. You get both. You get the neutral facilitator who keeps the peace and moves the process forward, and you get the loyal advocate who has your back and protects your specific interests. You've solved the fundamental conflict between neutrality and advocacy by hiring one of each. Second, the cost. Is it more expensive than pure mediation? Yes, slightly. You're paying for the mediator's time plus a few hours of your own attorney's time. But compare that to the alternative. A few hours of a consulting attorney's time might cost you $1,000 to $3,000. A litigation retainer for that same attorney will start at $10,000 and go way up from there. So for a fraction of the cost of litigation, you get the full legal protection of having a lawyer on your side. It's the ultimate financial leverage, a small investment to prevent a catastrophic financial mistake. Third, control. You retain complete control over the outcome just like in mediation. The lawyers are advisors, not decision makers. They don't take over the case. They don't file motions without your permission. They don't speak for you. They work for you in the background, providing the data and the safety net you need to make your own confident decisions. This prevents the process from spiraling into an attorney-driven conflict where your goals and your children's well-being get lost in the fog of war. Fourth, the process itself. It remains private and collaborative, but it's a collaboration built on a foundation of strength and knowledge, not on hope and ignorance. This is especially critical when there's a power imbalance. If one spouse has always handled the finances and the other has been a stay-at-home parent, pure mediation can be dangerous. The less informed spouse can easily be railroaded, not out of malice, but simply because they don't know what they don't know. With a consulting attorney, that power imbalance is neutralized. The spouse who feels overwhelmed now has an expert in their corner, explaining everything, leveling the playing field, and ensuring their voice is heard and their rights are protected. It transforms them from a passive participant into an empowered negotiator. And finally, this brings us to the most important difference of all, the outcome. Because both you and your spouse have had the benefit of independent legal advice, you are both entering into the final agreement with your eyes wide open. You understand the short-term and long-term consequences of every single clause. There's no mystery. There's no feeling of, I think I got a fair deal, but I'm not really sure. You know you got a fair deal because it was vetted by your own legal expert. This creates an agreement that is incredibly durable. The number one reason people end up back in court after a divorce is because one party feels they were taken advantage of, or they later discover a gotcha clause they didn't understand. This leads to resentment, contempt of court filings, and modification requests that cost thousands more to litigate. Attorney-assisted mediation dramatically reduces that risk. It builds a final settlement on the bedrock of informed consent, creating a peace that lasts. So when you're standing at this fork in the road, the question isn't just lawyer or mediator? That's the old way of thinking. The real empowering question is, what structure will give my family the best possible outcome? For many, the answer isn't choosing one path over the other. It's about forging a new one. It's about combining the compassion, efficiency, and control of mediation with the non-negotiable protection and strategic advice of a personal lawyer. This knowledge alone puts you ahead of 95% of people entering this process. You are no longer a passive victim of a broken system. You are an informed consumer who can now actively design a divorce process that minimizes damage and maximizes your chances for a stable, secure future. The choice between a $10,000 settlement and a $100,000 war isn't just about how much you and your spouse disagree. It's about the process you choose to navigate that disagreement. And choosing the right process is the most important decision you will make.